Lord. Am I audible, my lords?
No, you're not audible. But we can't help it.
No, my lord, I am audible, my lord. I believe I can hear your lordships. Your lordship.
Why this application?
No, my lord, I quite audible, my lord. Now, my lord, I came for my lord, some treatment. I'm in Kerala, so it was decided long. It was decided long before. It was decided long before. My lord,
Reserve the order on 20th September. They moved this recipe and this application behind our back. They don't give us notice on 24th my lordship. They mentioned before my lordship. And then they sent us a notice that the stay has been extended. And but they
no, my lord, now
conduct the COST meeting. Just look at the contents of the mail, my lordship. Just look at the contents, my lordship. I've highlighted the motion. On 25th September, the petitioner sent an email to Gauraksha, which is my client. I've highlighted the motion, my lordship. Continuation of order dated 16th September passed by Honorable Justice Shyam Suman. Dear sir, notice that the interim order passed by Justice Suman Shyam on 16th September continues to remain in force as on date. The said matter was mentioned on 24th September and it is on record that the learned counsel was duly notified about such mentioning. After the mentioning, the Honorable Court directed the matter to be listed. Continuation of arguments on Monday, 29th September today. Accordingly, status was granted on 16th September shall continue until further orders. Where is this coming from, my lord? I am not able to understand what will all conduct of the petition.
No, my lord, we had filed interim application on 21st. On 21st itself, we have emailed to everyone.
Listen. You see, we must tell it to both sides.
my lord, I am audible. Your lordship.
I'm not hearing you through this. We don't hear it through this.
Pardon me.
I must tell you one thing. We were working on this matter, going very deep into it, and we found that there are many loose ends which calls for an address. When this exercise was going on, we were trying to figure out how to deliver justice. There were many things we found. A mess has been created in this matter. It's not for us to give legal advice, but sorry to say, a pure mess has been created in this matter due to this multi.
No, my lord, who created the mess? Who created the mess? My lord, I'm so sorry to say, my lord, the court judges are to be found fault with that. It is time the judges apologize to the litigant. It is time to come. My lord, there's a concept of my lord. No, it is my lord. In all humility, my lord, here is human. It is here is human. My lord, a lady came before this court asking for a. My lord, your lordship may hear me. A lady came before this court asking for the protection of a notification which a matriculate can understand, and that was denied. She had to involve.
Will not hear it.
No, my lord.
Just 2-3 questions you answer and then close the matter.
No, my lord, now, my lord, just, my lord, 1 second. I'm the leading counsel. If I'm leading the matter. I'm leading the matter. I'm required. Your lordship will hear me online. I absolutely no problem. Your lordship is audible to me. I'm audible to your lordships. I'm here to.
We will not hear through this.
Pardon, my lord.
Tomorrow, satisfy each and every point.
Pardon, my lord.
That is here, my lord. At least here something you want to say.
No, my lord, your lordship may keep it for tomorrow. I'll come. My lord, I came for a medical treatment. My lord, I came for a treatment, and I'll cut short it. I'll cut short it. Will come. My lord, even if the heaven should fall, justice should be done. I'll cut short.
You are by the Division Bench of Honorable Justice Bombay. This order remains or has it been interfered with by any court?
Once they had challenged it before the Supreme Court refused to interfere. Thereafter, they filed a review
and I don't know what's the status of the review.
What is happening to the review? What is happening?
Review is pending.
14th October.
They haven't applied with the order.
That is not an issue. It's not been decided.
My lord, here.
Yes, my lord.
What has happened to that?
We had challenged that order before the Supreme Court. Supreme Court relegated to the Delhi High Court to decide the merits of the case. The same orders we can.
Why all these facts have been suppressed in the petition?
It is there, my lord. We had marked in that.
You ordered it in
All proceedings are.
You ordered it in first July, then the subsequent SLP, then the review petition.
My lord, it is there, my lord. Page number 364. Everything we had mentioned. The chart of proceedings, it is there.
They just filed a chart of proceedings so that it does not amount to suppression. But the orders in itself are not
Page
annexed.
number
64, my lord.
There is nothing for us to suppress. I think.
The concepts create bigger problem for their clients. Beyond that,
My lord, your lordship may not make any unnecessary comments.
Lord, can kindly answer.
Your lordship shall, my lord, your lordship should respect voice, and your lordship shall not make any comments.
He's only physically because he's
It
undergoing
was
treatment.
adjourned in the morning, saying that we have taken up it.
Yes, Lord.
If he has not come, we can't help it.
He's undergoing treatment in Kerala. Lord, can kindly unmute him.
Well, if the order goes in your favor, keep going. If it goes against you, take the
My lord,
decision.
we want to.
But we have not decided which way we'll go. But you have offended the court. We'll tell you one thing very surely. And we'll reflect in the order. What the outcome? These are not things which will sway our sense of doing justice. We must still decide a particular matter. But we are extremely
Kindly unmute me. Kindly unmute me. Kindly unmute me.
How come, Lord?
Unmute me. Unmute me.
How we offended the court?
You do whatever you feel like. We are not here to give you answers.
My lord, if your lordship is making such a statement, your lordship may explain how we have offended the court.
We are not bound to give you any explanation.
My lord, may they not pass such comments, my lord. My senior is appearing online.
But we are not hearing. Why is he not
Your lordship may
present in the
kindly
court?
unmute him.
Why is he not present in the court?
He is undergoing treatment in Kerala, my lord.
Why have you mentioned this matter and in the morning when we said we'll take it at 3, why did you agree for that?
My lord, my lord, he is appearing online. My lordship may kindly unmute him. There was some medical emergency, my lord. He has to go. There was a medical emergency. That is why he has to go, my lord. And he's unmute and hear, my lord, what you want to say.
You are going to argue something.
Then, my lord, it may keep tomorrow. We'll submit all orders.
No, it's not possible. First of all, when the
My
matter
lord, the Supreme Court orders, I think it had passed after the signing of this
Yes,
petition.
we don't have any problem. That is right. Once there is an interim order and the court has resolved the matter, that means the interim order is operational. That is correct and he has rightly.
But my lord, my hearing on that day after the conclusion of the hearing, my lord,
You can't tell the court there is a judgment, you can't do anything.
I'm just clarifying because my lord, IRC had duty to complete the process. If my lord, there is a status for it, I will not conduct the
Of course there is a status case. The order has not been vacated. So he is rightly informed the time.
all right. Then I will not conduct the
Yes. Yes, what do you want to say? You want to say?
My lord, I am just requesting to unmute my lord. He want to say something. My senior want to say something.
Okay, now just wanted to ask you.
yes, ma'am.
This proceeding before the Bombay City Civil Court, this is still pending. City Civil Court, there was a proceeding, is it still pending?
What's the he is not a party. I am not a party in the city civil
You
court.
are not a party. Anybody else?
We are a party. There was a suit by
Yes?
My lord, the city civil suit was filed in 21st December 22, my lord. And RP is appointed in 24. So the RP is not party. That suit is pending, my lord. But the
That's
commercial
correct.
suit,
But that suit is still pending.
yes, my lord.
Now, we wanted to ask one question. Who was appearing for response number 6? These are all questions because we are still thinking what to do with the matter. Unless people create disturbance, we would like to look into the matter and we will do it in our way. Doesn't matter who thinks what. Your primary ground was that, alright, after cloning, this is mandatory. Even the notification has clauses 1 and which substantially delineates that the corrective plan right of precedence to invoke them. That the plan is declare an account as NPA before the corrective action plan is implemented with a view to revive the proceeding. That appears to be the mandate of the notification. We are asking these questions to get a clarity on what is happening. Because as we said, we found it's become a very clumsy matter. Repetitive petitions, same prayers being rejected. So anybody who reads this will have a negative idea about the matter against the petitioner immediately. But we are trying to overcome this justice-oriented approach. After that, what happens, happens. That's another matter. Now, the clarification we are seeking from you is that the petitioner has been repeatedly saying that first we asked for renewal of the interest rate, then the loan account was declared as NPA. That's not your client, but on a generally we are saying. And it was done with a retrospective effect, denial of the benefit of moratorium. And when the surfacing notice was issued, the petitioner had approached the CTC court in Bombay, saying that please implement the MSME notification. That was one of the main ingredients. That suit is filed on the basis of a verification affidavit. These are the rules of pleadings. Now, tentatively we find that in some cases, the view expressed is that first of all, you will never approach. Secondly, even if you made an application, it was not supported by a verification of authorized person through affidavit. Now, why cannot it be said that in 2022, immediately after the surfacing notice was served, approaching the city civil court itself would be a clear manifestation of intention of the MSME to invoke the notification, and that suit definitely had facts and particulars which are supported by an affidavit. In that case, why cannot we say that immediately after the surfacing notice, petitioner did make a bona fide attempt to raise that plea? Did not succeed, no injunction, Supreme Court did not interfere, is another matter. If the answer to that question is in the affirmative, then the subsequent judgment delivered by Honorable Justice Dipankar Datta, the conditions mentioned therein is met by this. If not, the matter is different. This is number one. Number two, the SLP filed by the petitioner before the Supreme Court was dismissed against the judgment dated 11th of January 2022. That was dismissed. But subsequently, 6 other petitioners had filed SLP against the same judgment. And that will lead to the decision of pronate. Pronate says it's mandatory. But in the meantime, the SLP having been dismissed, the order of merger, etc., all these things happened, the review having been dismissed. 11/1/2024 attained finality for the petitioner. Although it was overruled by necessary implication by the pronate decision. These aspects we don't find was dealt with by any court. We don't find. Although Supreme Court says they are not remanding the matter, but the Supreme Court says it will be open for the petitioners in that bench. And even in this case, agitate other issues. What are the other issues? MSME is one. Other is that the bank has acted in breach of contract, withheld the money, so it crippled our business function. That is the only other issue we could see. That other issue is to be agitated where? Please listen to the queries, and we would want a response for it. Therefore, in the light of Promethe's judgment, where the petitioner, there was no determination except the order of the NCLT. That the NCLT said it is not applicable to tax. It is in this background that the petitioner is again and again saying that I have a right to the benefits under the MSME notification. And therefore, first beside this aspect, after we come to the question of that is their version, we can understand. But the difficulty here is it is for the petitioner. We are not required to explain. Don't ask for explanation from the judges. We'll throw you out of the court next time.
Lord, I only asked for you.
Remove her from the court. Remove her. Remove her. Get out of the court. You don't know how to behave with the court.
Lordship, I have not said anything offensive to the court.
Right.
With all due respect, I have not said anything offensive to the court, my lord.
Go out of the
Your lordship said I have offended your lordship, and I only explained that no such offense was intended whatsoever. I will leave the court. I will leave the court.
Leave the court. Just go away. Leave the court. Leave the court.
I will leave the court.
From the petitioner's perspective, rightly or wrongly, you have a decision by a court bench which has held that this issue is against you. All we are saying is, once there is a judgment delivered by a coordinate bench, our hands are tied, we can't help it. You have to either challenge it before the Supreme Court or get it reversed or recalled in a review. If the matter is open, then only we can go into the whole thing of order. If that is the judgment of another coordinate bench, there is a scope for a coordinate bench to reopen it. First, division bench says it was decided by 11/1/2024. That in a way may be acceptable, may be questionable because 11/1 has attained finality in the eyes of law, where the verdict is negative. But at the same time, don't need overrules that. But whatever it is, the subsequent decision of 1st of July, progressively holds
That 1st July, that order we had challenged before the Supreme Court, and we withdrawn because a review petition is pending.
So you have to pursue the review petition.
My lord, we had moved recipe several times, not only the once, we had moved 4 times, my lord, before the registry, even today. Sorry, yesterday also we have moved the recipe, even today also we just moved the recipe to list the matter.
Alright, so you get it. You get your pursue remedy there. But as long as that order is not removed, how can you expect a coordinate bench to give a view which is...
My lord, after that, my lord, that 1st July order, we went to the Supreme Court challenging that 19 March order, the review order, that has been admitted by the Supreme Court in view of that 8 July order, my lord. That is after 1st July order, my lord.
It is alright. What we are telling you is, the other issues which we are going through, and we will have to take a decision in accordance with that.
I mean, clarified biopsies are absolutely on the right track on the issue of finance. Now there is subsequently a parallel proceedings at the insolvency and bankruptcy court. Now the petitioner here is a promoter of Perfect Infra Engineering Limited, for which they are seeking the benefit of MSME. Now subsequent to admission order of 15 July 2024 passed by NCLT, there is a moratorium. There is a moratorium which is underlying under section 14 of the insolvency bankruptcy code. Now due to that moratorium, with all due respect, my lordships, the process should go on and no adverse orders can be passed against the company. Now
engagement. Please look here. Yeah. Yes. I am appealing this matter. We are relinquishing our engagement. My daughter has been insulted. The court insulted my daughter. We are relinquishing our wakalatnama. We are relinquishing our wakalatnama. We are relinquishing our wakalatnama. Hemali will not appear in this matter. We are relinquishing our wakalatnama. My daughter has been insulted. My daughter Maria has been insulted. Hemali, please leave the court.
You can submit a settlement proposal. However,
we are relinquishing our wakalatnama. We are not appearing in this matter. We are relinquishing our wakalatnama. We are not appearing in this matter.
My lord, at least my senior want to say something. At least hear, my lord, what you want to say. My senior want to say something. It is his matter, my lord. We are juniors also. You want to say something, my lord? No, it has.
No, I am relinquishing my wakalatnama. I am relinquishing my engagement. I have relinquished my engagement. My daughter has been insulted. I have relinquished my engagement. My daughter has been insulted.
Section 238.
Ask him to leave.
That is the overriding effect. With the law being a central statute and the later
Ask him
and
to
the
leave.
effect over all laws. So if at all, if there is a conflict issue, MSME also provides for resolution, IBC also provides for resolution. If there is any conflict, then IBC will prevail. So they were given a fair opportunity. It is not that they were
No. Question is different. And queries are made only to help us really understand, because it's, as we said, there are multiple petitions. And we are trying to figure out. There is another late petition we are told which is filed, and we don't know where it is. Here also there is a direction to constitute a committee and refer the matter for that action plan committee for incipient stress and mitigation of risk. Is there another petition for you?
Lordship, I was before Justice Chawla on Thursday, and a similar matter was reserved for orders. Exactly the same submissions were made, that it is the duty of the bank to identify incipient stress, and in light of that, the SARFAC proceeding should be stayed. The petitioners, Mr. Nitwara,
Please leave the court. We are not appealing this matter. We are looking at my wakalatnama. My daughter has been insulted. Please leave.
were made parties to that.
Alright, so that matter is not before this court.
Yeah.
They are not concerned.
With the exact similar
The
issue.
claim is that in these petitions, repeatedly the petitioner is saying one thing. Adjudicate on my rights to get the benefit of this MSME documentation. Unfortunately or fortunately for whichever side, at some stage, 2024 came in, that judgment became final for the petitioner but overruled by the Supreme Court subsequently. Before that, it had been granted. So it is a prospective overruling kind of a situation. But 11 holds that petitioner is on facts, he expected his own facts. Petitioner is now entered any of the releases. Says that it is a case of issue and also individually on facts findings are reported. But the petitioner is saying that this is not constituted as
Lordships, what is happened is also this. Like by Justice Gregori's consent order, we were sent back to the NCLT. This is post proceedings coming into play. So the adjudicating authority considered proceedings and thereafter passed another order which confirms that earlier order. So proceedings has been
In the court.
8 years.
yes, but, so this court, as this court considered proceedings right of petitioner,
Okay, I have order.
we want to see this.
Justice Mukesh order.
Just check it once.
Justice Mukesh order.
Is there any decision?
No, I will not say, my lord, to submit anything. He want to say submit my senior
No,
is all.
we are relinquishing our wakalatnama. We are relinquishing our Vakalatama. We are relinquishing our Vakalatama. We will not take insult in silence. We are relinquishing our Vakalatama.
Madam, my senior is here. Only you want to submit something. They are submitting against the submission. You want to say something. I cannot make submission, madam. I have no instruction to argue this matter.
That's a question which is posed.
We are relinquishing our Vakalatama. We are engaged. We are relinquishing the matter. We are not appearing this matter.
Paragraph number 22. A judgment has been submitted where the judgment
recently has been dismissed and
the review is pending. Review is pending.
there was a celebration of income.
Review petition is still pending. Also, as continued, they don't get a given order. Another fresh rate petition. So this is one of those price rate petitions which medical I'm very happy to agree. Why not? And I get that. But this is.
But where it has been decided, issues are not decided, my lord. And the previous order has been only withdrawn. Nothing has been decided.
The question which will also post on students with respect to the pending civil code and whether that pending civil code would is part of the notification. To answer that question, if you want to kindly come to the brief reports which we have submitted. The 13th notice is of 14th of October 2020. After which there is a reply which is given by the petitioner and the company in the capacity as the director. In that reply, I have annexed it at page number 88. It's a small email which is given as a reply to the 13th notice, where the only contention is that we are agreeing for a restructuring. So, as far as the later judgment of Honorable Supreme Court, 28 July 2020, Justice, the Honorable Supreme Court has mentioned under paragraph number 6 that the understanding of the Supreme Court is that when the 32 notice is issued under the Surface Act and the borrower in it reply to its objection 13(3) capital A, they take that objection and if they take a stand in that reply to the 32 notice with respect to the MSME application, then the entire proceedings can be stayed in abeyance.
But then we replied to the 32.
Our learned man should not that point is given in the clarification by the Honorable Supreme Court in paragraph number 6. Paragraph number 7 and 8 provide for a further mechanism that in the case when a section 14 application is made and an orders are passed, and at that stage when a borrower is coming forward and taking a stand that it's an MSME, that such a proceeding or such a stand should not be appreciated by inputs, and that is exactly what was done.
No, these are all your submissions. They are asking, has these aspects of the matter adjudicated by any forum? Has it been examined by
This is the latest judgment. This is the latest which narrows down the scope of essentially pro rates floods. That page number 301.
that is my Honorable Justice Dr. Dipankar.
Yes.
That is of 28th July 2025. So it would be very recent for this bench to consider.
Because in paragraph number 8, it is clearly mentioned that if the MSME is coming at a later stage, related to what the recovery proceeding, then such application should not be allowed.
That's what we are asking you again and again.
Not sure.
If this plea was raised in 2022 immediately or few months after the receipt of section 13(2) notice, how can it be said that this stand is taken only to thwart the...
Unless my lawyer friend just mentioned that the suit was filed in November of 2022. If your lordship will see my compilation, my list of dates, we have mentioned remand notice was of October 2020. After that, 13(4) notice is of July 2021. And after that, December 2021, we had a section 14 order, after which they approached the DRT. There was a conditional order which was passed. They was directed to deposit 4 crores. They did not do that.
But that was not it. When they closed the civil court by filing this suit,
That was after.
that's like nothing had happened except for issuance of 13(2).
There was a section 14 order which was in place with respect to the property in Pune. There was a Lavasa property which was there. That order was there. That is why they had filed an essay before the DRT Pune. That is also annexed at item number 11, that conditional order of 24 March 2022, which is 9 months before the suit was filed.
So they failed before the DRT, they failed before the DRAT. DRAT also there was a waiver application which was decided, conditional order was passed, they did not comply, extension was granted, extension was not complied, it was dismissed. That dismissal of DRAT. So as far as the challenge to the surface action is concerned, they have failed in DRT. So their remedy to approach the Honorable High Court by filing an writ to challenge the DRAT order which still has not been filed. So, by filing of a civil suit, they are clearly approaching the substitute forum to adjudicate the same issues. And also, I should point out that there was a notice of motion which was filed asking for reliefs under section 32, that entire procedure should be stayed because of this notification. But that will also be rejected by the Honorable City Supreme Court. Under section 34 of the Surface Act, civil courts are barred by passing any injunction on 13 or section 13 proceedings.
Are you saying that here is some delay? For a moment, let's not go too deep into that. Order. That it is already that this issue has been decided. Merely because they wrote an application on September 2023. Their rights are established under the MSME notification.
Yes, but what will have to be seen? What will have to be seen is that after the 13-2 notice, there were various steps which were taken by them. Before the DRT, there was no plea of MSME which was taken. Under the before the Honorable DRAD, that argument was taken for the very first time. So whether a MSME who has taken steps, who has replied to the demand notice, and in their reply to the demand notice, they have not considered to the benefit of MSME, and they have merely asked for restructuring of the loan. In my respectful submission, my lord, such an entity at a later stage, when the bank has a section 14 order and goes to implement it, they cannot slap me with an MSME notification saying that I'm entitled to an MSME benefit because I'm an MSME. That Cronish judgment as well as the later judgment of 28 July of the Honorable Supreme Court mentions that such entities should be stopped and such MSMEs should not be entertained. That is clearly mentioned in paragraph 6, 7 and 8. And if your Honorable comes to page number 300 of that compilation, that I'm referring to the same order of 28 July 2025 of the Honorable Supreme Court. It clearly mentions that in such a case, so you know, bring a query that whether a factor of delay will have to be considered by the bank. It is not upon the bank, it is upon the MSME to first approach. And if the MSME approaches with the prior application and affidavit, then obviously the bank will consider. But what will have to be noted is that the time or the stage under the 32 proceedings at which time is approaching. Because the Honorable Supreme Court has also very carefully mentioned that after the 32 notice, in the reply under 13(3)(a), if an objection is raised, then the entire proceedings can go in appearance. The Honorable Supreme Court does not say that after section 14 also such an application is filed, then the bank should consider it. The Supreme Court carefully says that after 14, if you cross the hurdle of section 14, the bank should not be slapped with an argument that because it's an MSME, you now entered in it. Such a please.
Sir, I as respondent of 126.
Yes. Who wants to argue for petitioner?
So we relinquished Wakalatnama matters.
Sorry?
We relinquished our Wakalatnama. We are not agreeing because why the virtual facility is provided? My senior has not been heard, my lord. He is not been unmuted.
Tell him when give him 15 minutes. They have been making it very clear again and again that these are not matters.
No, they are being arguing that I have just told the court that it may be keep for tomorrow. He will present.
No, we are not. For me, my dignity is most important. My dignity, self-respect is more important. Has been insulted. My daughter Mariam Nirmala has been insulted.
Mr. Navambara, you want to argue?
For nothing we compromise for dignity. We are relinquished our Wakalatnama. Nothing more important. The court has insulted my daughter, Maria Redumbara. Advocate shall not be insulted.
Do you want to argue?
Wakalatnama, we are not appearing in this matter.
So that's it.
I believe
What for the petitioner?
I'm petitioner.
The counsel is not appearing, doesn't want to argue.
So he is been muted at the
Oh, we are hearing now. We'll decide, no? That may be it.
Can
Can I have a talk with him?
So that is where the matter is falling. But that is correct. That once there is a status quo order, the judgment is resolved. Till the time the judgment comes,
About
status quo order will be holding the field.
because that was the indication that my lordship gave. That's why I proceeded for the meeting. But now that my lordship has verified, I am not sure.
What is this? 13, 14, 15 cases of the same point. Again and again, year to year. The main issue is it's a very interesting point of law. It's a very interesting. We find that it's a very interesting point of law. And calls for deliberation, it calls for application of mind. What has happened to the other cases who is the pronate and the six? Yes, you have to say something.
I'm not able to reach now, sir. Requested to give a date.
You want the matter to be released to this court, is it?
No, sir. Give a date where I will ask to come physically. The Lordship has been kind enough to go so much in. Lordship has been kind enough to go so much in detail in my matter that no other court has given such a hearing.
Why there is so much of disruption here? It is for the court to hear matters in our as per our
I apologize on behalf of my counsel.
Is this the conduct of the counsel?
Sir, I have paid 7
explanation from the court.
and sir, I have paid 7
You see what has been
some bank and also in the putting all every
If
communication
there
with
is
the
an application, but there is some motive is being
but
projected.
he had some medical difficulty, otherwise he never misses my matters. He had a medical
What a
difficulty.
way we expect the counsel.
I know,
Such
but
illustrious High Court with such a
sir, my
wonderful
personal
law.
request to keep on another date when he can come.
And every judge is complaining about it. We have seen the orders.
I apologize on
We have seen the orders. Every judge is either this cost of the report to every matter the judges are expressing dissatisfaction. You are not allowing the court to hear a matter and deliver a judgment. These are very intricate issues of law.
I understand.
These matters are required to be heard in a proper ambience. After we reserve the judgment, you file an application. We still granted you this when your counsel is not present.
Yeah. But sir, he had really medical difficulty. I know for sure.
We allow them matter on.
And we give another close date to him.
Then the DT comes and says, ask for the explanation from the court. What kind of a behavior demeanor is this?
I
Is
apologize.
there something called the court demeanor or not? If it is not there, then tell us, then we will. What explanation? The application will read on this. See what is written in the application. Have you got a copy?
Yes.
Yes.
Where is the interim application? Let us see.
What this application does is create what my Lord Sir will do.
The application is for this Supreme Court
My Lord Sir.
order and the review pending review. That's all the application.
No, the application which has been filed on 24th.
Yes, sir.
What is the number of it? Not this, 24th. What is it? This is what?
Like, I have
30255.
Yes.
wherein there were observations that I being statutory body and not a the notification would not apply to. So
the committee
was SLP and SLP was dismissed. And like I said, plus simultaneously SLP and reviews are once.
So, what do you want? What is your request? Your counsels are not appearing.
Now I'm not unable to speak to him in person, and I will speak to him after this matter is over.
What is your request today?
So my request is out of 9.5 crore, I have paid 7 crores to ICICI Bank over and over. Sir, even last year also I paid a crore of rupees in spite of such litigation. So my intent of resolving is very, at least 5 times I have requested TDB through this court of justice. 1 minute, let me see. So even through Justice Kolabawala in WP 4647 of this Justice Chandurkar's order, also before that Justice Kolaba was handling, I had given my resolution plan through the court to them that I want to pay because this is a new technology and I took and COVID and all, it took so much time to establish and get the sales and now I am ready to pay and now at TDP 4.5 crores and ICICI 1.6 crores, sir. And if this NCLT is out, I will within 6 months pay, sir. I want to settle this. Please let me speak. Sir, I want to survive this company. I have 1996 I started. I have sold my gold ornaments and invested in its first child. My other 2 children are elder. So this is my first child. I cannot think anything about other than perfect getting up in the morning. I have 300 employees. Because of the ICICI Bank now only 25-30 people are there. But this new technology is a survival which I promise this lender that I will.
Your business is in manufacturing solar panels.
Hybrid solar panels, sir. It is in Mazda Port. 60 panels, sir. You see what is the bill of Mazda Port? We have put 60 panels. Nagpur High Court, I have put 10 panels. See the electricity bill, sir. Only ACs runs on this. We are the ones who got this technology because of TDP. And in between the ICICI and TDP, they crushed me to death, sir. Still, I am trying extremely hard to make this company survive, sir. Because that is my life, sir. And still I am requesting. I have paid out of 9.5 crores. I have paid 7 crores to ICICI Bank. What are they talking? And it is the loan is SMEG group, sir.
What was the amount originally taken from ICICI Bank? What amount?
Total I had 17 crores limit. I gradually reduced because I had little loss from certain receivables. Lavasa, I was doing contracting. So I reduced every year. I reduced to around 9.5 crores. After that, I sold my factory, another 2, and I paid on. After 13 to notice, I paid 7 crores. 13 to notice, I paid. And TDB, I requested at least 5 to 6 requests that you please give me a plan. From March 25, I will pay. So, not a single meeting. So many times I went to meet the secretary myself. They have to open the register and see the number of times I went and met the secretary of TDP that you give me a plan because I have to have this company survive, sir. I don't know what type of vengeance they had on me myself. And still this principal amount I can pay in 6 months time, sir. Just NCLT, control and management, has reached a listed company on National Stock Exchange in 2015. There are 800 shareholders. And these 2 lenders are just want to just kill me. That's it. Kill the technology to India. Sir, I'm not joking, sir. You take one day, go to Mazda Port, go to the terrace and see what perfect is done.
Alright, we appreciate what you're saying. Now please tell us, you know the court proceedings have to go through certain decorum dignity. As we mentioned in the morning, we were giving very minute attention to your case. The matter was heard sufficiently at the request of your counsel. We heard it. Judgment was closed. After that, normally these are not done. And comes. And then found a little difficult the manner in which things were dictated.
But in any case, these are things which will not come in the way of delivering justice. That's why we were asking them these questions. Please tell your clients that you should behave properly. Because what happens is it causes destruction in us. We lose sight of the original. I have been repeatedly telling I have a problem with my ears to EC. I cannot hear matters. And then there is a problem in this court. You see what is the quality of sound. I cannot follow. When we hear a case, we go minutely into the facts. We don't want to place a simple explanation. So therefore, lengthy hearing that this is not a matter of right. In a particular court, a particular judge may announce, but in my court, I will decide what is the correct. I have a problem with my hearing apparatus, so I do not hear this. And I will not hear. Then what will happen? The young lady here says, I want an explanation. It's not things which go down well. It's the market. The mood has its own majesty. And we're all happy that we have to be so, I have to be so strict. But these things cannot be controlled. Youngsters, they should have some sense of honor and dignity.
I apologize, sir, on my
Not a place where you can say whatever you feel like. And what has happened, the habits have fallen. And are we not entitled to make our queries first the way we want? How can it be that I will argue first, I will have to be heard? These terms and conditions will never agree. Decorum of the court has to be maintained. So, whatever it is, whatever has happened, has happened. Now, what do you want to tell us? You tell us what you want.
Sir, if this NCIT order is set aside.
No, that's all merit.
Sir, then 6.
Is your lawyer appearing and arguing the case?
Unless I have a proper
Deliver our judgment.
I request one more date, sir.
One more date for what?
To complete this whole thing, sir.
What date is that? What is that date?
Within
Have it on Friday?
Friday, yes, sir.
Friday.
It will do, sir.
Heavens will not fall.
Yes.
And in any case, we are looking at the issues. That much we can tell you. We are looking at the issues because there are some areas where we are still not convinced whether it seems when she said I have a lady interpreter, so give me that's when the ICIC Act came with this law of declaring it NPA, that too with retrospective effect. Each of these things require a detailed consideration by the Court of Law, which have apparently not have happened. If these have happened and then judgment is delivered, then no, you are not entitled. It is understandable. But if this has not happened and the petitioner raises a plea, what is the option from the court is the facts? That's what we are trying to accept. On one hand, there are orders of concrete bench, which now may decide the issue. The other hand, is legal issue. So we give her one more opportunity.
Yes.
Coming Friday at 3 p.m. But it will be hard physically,
Yes.
and we will not grant any more returns. Not grant any more. We'll hear this extreme application. Further arguments that them, yes, we are entitled to satisfy ourselves. That, if they feel that there is something yet to be argued, the guidelines will not pass. What is objectionable is the language and behavior. Otherwise, there is nothing. The litigant has the right to come and say that we want to argue. That's the about everything. As long as the behavior is sober and the court's decorum is maintained. So, do you give an assurance that your clients will
Yes.
your
Yes.
lawyers will maintain court
Yes.
decorum?
Yes.
Do you realize what has happened?
Yeah, understood. Yes, sir.
They not joined
Such status okay.
But what is your response to this offer of ours? 6 months you will repay the entire amount?
Also, that I did ask was on the lines of I have to send another 3 crores to them. No, yes. I will take the
Please, how it is? You are representing?
I'm appearing for the technology company. And the sanction was of 7.5 crores. They contribute the loan. They put it in.
What you said they are unable to furnish collateral. After disbursing 4.5 crore, what more collateral was there?
They contribute certain loan conditions wherein they were supposed to let us know whether they have been going to the engagement. So some of those conditions were contributed. Now, when a proposal was given, they said you disburse another 3 crores. And thereafter, he has come and
I say you want your money. She wants to save her business. So are we in a situation where nothing can be done? Is that your stand?
Look, there has been right. Always this has been right to us. Due to insolvency process, there are 7 resolution plans who are willing to contribute with the company and take over the company and run the affairs of the company. So it is not that if a petitioner is not in a position to pay the
Why because legalities cuts both ways. But we are saying that you are for the TDP, right? You are
I'm for the resolution professional.
resolution. Ultimately, if you get your money, which is legitimately due, what is your problem?
Because I have no difficulty.
And what about ICICI Bank?
Like candidate last year also the same position was taken up in the review team. So in the review team before Justice Gadkari also that review, that order is there where it was entertained, the plea of the loaded petitioner here was entertained. Justice Gadkari was pleased to hand up time to deposit some money to show the bona fides. And that also has not been done. And despite that failure, there were letters which were exchanged between the bank and the
Where is your source of capital?
You are not getting amount. The difficulty that time was, sir, my investors are ready. And they say if the control and management is in your hands, we are ready to pay. Because of the NCLT order, the investors were not ready to put in it.
Bring the investors, let them find a...
Yes, sir. They are ready.
In one go you close it.
Yes, sir.
In one go you close it.
Yes, my investor is ready to come and give a commitment.
You will pay in one go. In one go she will pay your debts.
Yes.
she's making a statement. This statement was made earlier before predecessor.
No, we'll not go with that.
We get our money back.
We'll have the affidavits from the...
Yes. Yes, sir.
Bring in the investors.
We are well aware of these proposals which keep coming
Sir,
to us, but nothing because
the investor is very clear. If the NCL management is in your hands, we are ready to give money to come.
in fact,
That is very clear.
Sir, order we set aside, then we put in money.
No, sir, they are ready to give under affidavit. No, sir. Sir, they are already, I have 800 investors in my list of shareholders, existing shareholders, and there are key 10 shareholders. They themselves have given expression of interest last time. I again have to reach out to them and say,
your bankers, your financiers have lost trust lately.
but sir,
What can you do to bring it back? Tell us that. It is not the job of the court to get into all these negotiations.
understood.
But if they have lost trust on you,
I can pre-deposit.
you are able to bring it back.
Sir, I can pre-deposit some 10% or 15% amount, and then balance once that is set aside, I can give condition to the court. Sir, because had I had money, this situation would not have arrived, and there is a precondition of the shareholders who are investors that you come control and management, madam, हम आपको देने के लिए तैयार. It is true, sir. It is nothing wrong, sir. Without management, they will not money. They are looking at my face. We know the technology, sir. No, I don't recognize the IBC. Sir, I don't recognize IBC. I will not go to if withdrawal is there out of court, I am ready. Sir,
I did not wanted to bring this up, but
I don't recognize IBC.
there is one concern of the petitioner who is done by
No,
the
sorry, sir.
son.
No.
During the insolvency process, transferred around 20 lakhs to that account. Business is completely diverted. Today the business
They are contractors, and it is in the due course of business. You don't bring those things in and confuse.
Just to highlight the concern of the petitioner, I have to say.
I am ready to pay money. That is the conduct. That is the most important conduct. That's all. Not at all.
Right. 3rd October is not far away.
Yeah.
But after 3rd October, which way things will go, there may not be another chance. Both sides think about that.
Sir, time and again, this loan is SMEG loan, sir. The group is small and medium enterprises group of ICICI Bank. The group itself is ICICI. And I am asking for my right, my constitutional right, sir. Just give me time to pay. That's all, sir. Time and again I am asking just. Constitutional right will never do professional rights.
So we are conscious of your interest. Try to balance this. Don't want to hurry into a decision. That's the only point here. Let us
Yeah.
Grateful.
So matter. You know what it is.
This matter has made the same field last occasion also on compulsory Saturday.
What is your matter about?
First October. I have served the respondent number for management as per.
Lordship, only the thing is that he has given some compilation of judgment that we have to see that, and whether it is covered or not covered, that is the statement made, Lordship. This short issue, Lordship. Yes.
Court is not available next week.
6th October and the same matter.
Yes, Lordship.
Great. My Lordship, may I mention serial number 45?
45.
Matter is already adjourned and granted 4 weeks time. So at least early interim order may be continued. And my presence also recorded. My presence also recorded.
If I need to continue.
Lord, may I mention serial number 2? It's a fixed matter at 4 p.m. Lord, it's a contempt appeal and for the respondent.
I appear for that.
Lord, today it was supposed to be taken up for final hearing. The ad interim is continuing on the basis that it will be heard. The only thing is, my Lord, it's a suo motu contempt proceeding. They were to pay 5 crores to purge the contempt. They've only paid 1.5 crores. So that's the status. Any date, my Lord, where my Lord could take it up. In my submission, my Lord, there are 5 or 6 orders latent in each of the orders of this court, and therefore the single judge has passed a detailed judgment holding them in suo motu contempt. Your Lordship's predecessor had passed an order on 30th July saying that the matter will be taken up for final hearing. This is now the Chief Justice. And therefore the ad interim was continued. Any date, my Lord,
Then next week or next year.
I am ready. I was it.
Next week, Wednesday.
Wednesday. Not any.
Except this